Hello. In this video we're going to look at the common law offence of manslaughter and basically look at structuring, particularly in relation to problem type questions, where you need to think about how you're structuring your analysis and your application of the law to a scenario where somebody dies. Now, manslaughter is a common law offence, it's a single offence, but it becomes quite tricky and sometimes quite tricky to understand and to apply in practice, because although it is just one common law offence, there are multiple routes for how you can reach the outcome of a manslaughter conviction. And it's this that I want to talk about now, just to think about and clarify. It's also something, of course, we discuss within chapter 6 of the textbook, and really alongside this discussion it's useful to look at the flowchart that we use within chapter 6, which again gives you this idea, hopefully, of the structure of your analysis in this area. Now, whenever you look at a problem question and a potential criminal event, you should always start with applying what is the most serious potential offence within those circumstances. So within a homicide type scenario, i.e. you have a defendant and somebody is killed, someone dies, then you should always begin with the potential liability of our defendant for murder. So within that, when you're looking at murder, first of all, the actus reus of murder. So has our defendant done something which has caused the death of a person? And you can look at that scenario. Now, if the answer is no, if there's no causation, if our defendant hasn't killed that thing, or if indeed the thing that's killed isn't technically a person, if there's a lack of mens rea, then there's no homicide offence. There's no murder and there's no manslaughter. And you can look for alternative forms of potential liability. However, if the answer is yes, that there is the actus reus of murder, it has been satisfied, you then of course look at the mens rea. Now, the mens rea of murder requires our defendant to have acted with the intention to kill, or the intention at least to have caused serious bodily harm. Now, when you look at that scenario, this is when it becomes particularly important when you're thinking about your potential manslaughter routes. Now, if your answer to the murder mens rea question is yes, they did act with the intention to kill or cause grievous bodily harm, then your answer, of course, is that they have committed an offence of murder. Now, from there, we look to potential defences. Now, from the defendant's point of view, they would ideally like to rely on a complete defence, which would lead to an acquittal, so something like self-defence, for example. But if none of those complete defences are applicable, then in relation to murder, we also have the so-called partial defences. These are defences that don't lead to an unqualified acquittal, but rather lead from a conviction for murder down to a conviction for manslaughter. So this is our first route to manslaughter, often referred to as voluntary manslaughter. There are three partial defences, each of which of course we discuss in detail in chapter 6. The first one is a loss of control type defence. So you say, yes, I committed murder, but I did so whilst out of control to some extent because of some extreme provocation or because of some kind of extreme fear. So if you satisfy the rules of that, your conviction for murder becomes a conviction for manslaughter. Another one would be diminished responsibility. Yes, I committed murder, but there's something wrong with me in such a way that I should be partially excused. Murder becomes manslaughter. And the final one is if you killed in the circumstances of a suicide pact. Again, what was murder becomes manslaughter. So that's the first route that we call voluntary manslaughter, and that is basically where there is liability for murder, but there's a partial defence to murder, which brings us down to manslaughter. The other alternative route comes about when your answer to the question of the mens rea of murder is no. So you found the actus reus of murder, that is satisfied, but when asking if the defendant acted with the intention to kill or cause grievous bodily harm, your answer is no, they didn't act with that intention. So therefore there is no liability for murder. So this time, because we don't have liability for an offence, we're not looking at partial defences or full defences, but rather we're looking for lesser forms of offence. And this is what is commonly referred to as involuntary manslaughter. So we have a series of manslaughter offences, which again leads us to the result of manslaughter liability. The three main manslaughter offences in this way are first constructive act manslaughter or unlawful act manslaughter. This is where essentially a defendant commits a base offence in dangerous circumstances that leads to the death of the victim. We have gross negligence manslaughter, where extreme negligence on the part of the defendant leads to the killing of the victim. Or we have reckless manslaughter, where our defendant has killed whilst foreseeing a risk of killing, as opposed to intending to kill or cause grievous bodily harm, which would be murder. And that, as I say, if you're found to satisfy the elements of any one of those offences, then again the result is liability for manslaughter. So very, very importantly, we have this single offence of manslaughter, but the two separate routes are defined by, or are sort of created by, are judged by our initial question about the mens rea of murder. Actus reus of murder satisfied, do we have the mens rea of murder? If the answer is yes, then we consider defences and the partial defences that can lead to manslaughter. If our answer is no, there's no mens rea for murder, then we consider the lesser offences, the involuntary manslaughter offences, which if they are satisfied, again leads us to this conclusion of manslaughter liability. Thanks.